your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome. Welcome, everybody. Sorry about that. Welcome, everybody. Today is Judge Lynisse Bryant. I got quite a bit of Lynisse Bryant. Everybody loves Judge Bryant. I was kind of mixing it up a little bit because you get into the same routine, and you know, if I get a bunch of different judges, I'm going to switch it up. It's not the same routine all the time. So, I've been working hard on all this. I've been accused of not doing anything on this channel, but being lazy. And that's not the truth. Because when I get done doing a live stream, it doesn't end right there. I have to do research. I'm doing research to get more content that I could add to this channel. So it doesn't stop just by, when I do a live stream. I have to set up all the live streams. I got to do the live streams. I got to get the content for the live streams. I'm not lazy. I do the work. I'm on here every day. Since I've restarted this channel again, I've done 140 live streams since this channel's been up. So I don't do the work. Yeah, I made all those videos. I made 6 months worth of content to be uploaded to this channel. Not doing anything, please. But those people are not banned here. Everybody's welcome here as long as you behave yourselves. If you behave yourself, you're welcome here. If you start drama or start shit, I'm going to ban you. And this time it'll be permanent. There is no no-fly list on this channel. I believe in everybody getting a second chance. And that's how I feel about it. Everybody has a right to a second chance. All right, so let's get started with this. So let's make this bigger.
Okay, blessed assurance. Let's try Miss Wilson again.
Okay.
And then we could bring Miss Moshrick out because she's finished.
Okay.
Miss Wilson, we can't even see you, ma'am. What's going on? Yeah, Zoom court has lost its appeal. Zoom court has lost its appeal. We're going to be coming back in person. This is case number.
Uh-oh, I've seen how this ends.
Have you? You've seen this film before?
I've seen this film before. Yeah, shut!
I can't even see. Who is this?
This is to be Danielle Wilson, Your Honor.
Okay, thank you. Yes, this is case number 234469501. The people of the state of Michigan versus Danielle Wilson. The defendant is charged with 1 count.
On behalf of Ms. Wilson, Your Honor, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Judge, it's the first scheduling of the pretrial conference. I'm going to ask the court to adjourn the pretrial conference to give the complaining witness one more opportunity to appear. Your Honor, for the court's information, the second defendant was scheduled for August 17th for an adjourned pretrial conference.
Who was the co-defendant on Wilson?
Miss Haley.
Oh, okay.
Under 830.
So did Ms. Stevenson, did you all represent Ms. Haley?
I have, my note indicates that Ms. Haley should be here as well. Just 1 second, Judge.
Both here. I already did Ms. Haley. Ma'am, put your phone down.
Oh, I'm sorry.
You just
Okay.
don't text and stuff while we in court.
Okay, thank you for that information, Your Honor. In that, Ms. Haley was defendant number 2. Our normal practice to request that the court appoint counsel for for subsequent defendants. So we usually take defendant number 1, Your Honor. So I will leave that to the court's discretion as to which of these defendants we should represent.
I was waiting to see, I was just waiting. I was wondering if Ms. Wilson was going to unmute herself and apologize to the court.
I'm sorry. I just picked my phone up. I have an interview to be at. I'm not going to be able to make it, so.
And apparently you blaming that on me.
No, ma'am.
Well, your attitude sucks. You talking to me random. You talking to me like I'm on the street. You talking to me like I ran into you in the neighborhood. You talking to me like I'm not Judge Lynisse Bryant. So the fact that you scheduled an interview on the same day that you had court, that sounds like a poor choice and a bad decision. That sounds like a poor choice and a bad decision.
I did not schedule
what you're not going to do is come into my courtroom and be disrespectful. That apology was, I guess I shouldn't have even mentioned it because it certainly wasn't sincere. So let me just help you with something. You can continue to come to my courtroom with a bad attitude, and it's only going to work out poorly for you. It's not going to work out poorly for me. it's only going to work out poorly for you. So when one has court, then you have to understand that court could take, I'm not even going to continue because she is really on her way to contempt. She is really on her way to contempt. So let's go ahead and let her come in person. Okay. We're going to come in person. So the court is going to adjourn Ms. Wilson's pretrial conference to next week. She's going to come in person. I'm going to set the matter for 8:34. She's going to come in person on let's see, today. Oh, that's today. So we're going to come in person on Monday, July the 24th. And we're going to come at 8:34.
Your Honor.
24. At 8:34. Failure to appear is going to result in the bond being revoked, court issuing a capias, and the court is going to set the bond in the amount of $5,000 cash surety plus a GPS tether. Is there anything else for the record?
My mother has an appointment on Monday. She just had knee surgery, and I have to drive her at 8:30 in the morning.
Okay, well, I mean, we all have to make choices. Is there anything else for the record? Because we wouldn't be dealing with your mother's surgery if you was respectful today. So if you didn't come on my court today with your stanky attitude, if you didn't come on my court today with your disrespectful disposition, if you didn't come on my court today with your rude behavior, then it wouldn't even be an issue about your mother's surgery. Wouldn't even be an issue about your mother's surgery. So you're rude and disrespectful, Miss Wilson. You're rude and disrespectful. And the fact that you're talking right now shows me how rude and disrespectful you are. You have no contriteness about yourself. You have no humility about yourself. You're simply rude and disrespectful to the court. But there's never going to be a day that I allow you to come to my job and be rude and disrespectful to me without consequence. You're rude. You're disrespectful. I didn't charge you with the crime. I didn't set your court date for today. I showed up for work. And when I got up this morning to show up for work, I didn't say, let me put on a robe so Miss Wilson can be rude and disrespectful.
Amen. That's the one thing that you don't do. You don't go into a court of law, even if you're on Zoom or you're in person, and be disrespectful to a judge. When you go to court, you're supposed to dress. If you're in person or you're on Zoom, you dress appropriately and you act appropriately, because these judges can put it to you, no problem. These judges don't play.
Ms. Stevenson, I'm going to send Ms. Wilson back to the breakout room, because if she say one more thing to me in her tone, she going to jail. So I'm gonna let her tell you about her mother, because if she says one more thing to me in that tone, she's going to jail.
Okay.
There is an appropriate and respectful way to ask the court. If you turn your head from me one more time, I'm going to hold you in contempt. I promise you. I make a promise to you.
Listen up, parents. Want to start building generational wealth and happiness for your children in less than 10 minutes?
we're gonna take a recess. No, Miss Modrick, come on camera. I won't recess before I let you get discharged. Come on camera. Okay. Here we go. All right, let me turn it on. All right. Ms. Stevenson, are we ready to go back on the record with Ms. Wilson?
Yes, Your Honor, if it please the court.
All right, I'll do Wilson and then Goodwin Jackson. And then did you get a chance to speak to Mr. McLean yet?
Not yet. I'll do that as soon as I finish with Ms. Wilson.
Okay. All right, we're back on the record then with case number 234469501, the People versus Danielle Wilson. Ms. Stevenson?
Janice Stevenson, again, appearing on behalf of Ms. Danielle Wilson. And Your Honor, we would ask that this matter, that if the court is not going to grant our motion to dismiss, we would ask that this matter be set for adjourned pretrial conference requiring the complainant's presence, along with the co-defendant, Ms. Sharniqua Haley, whose matter was heard this morning.
I apologize. You're asking me not to adjourn the matter to make have Ms. Wilson come in person, but to set it with the co-defendant?
I am, Your Honor. Yes, that is what I'm asking for, Your Honor. Ms. Wilson.
Why would I do that? Ms. Wilson was very rude and disrespectful.
For judicial economy, Your Honor, and I know that that's not the court's highest concern.
It's not even my concern, period. Ms. Wilson was rude, disrespectful, and it's not my concern, period.
And I understand,
she doesn't
Judge.
know how to come to court on Zoom. She needs to come in person.
And she definitely,
for her any courtesy. I'm going to tell you the truth. That's a courtesy. She
will be coming to court in person going forward.
Yeah, Zoom court has lost its appeal. Zoom court has lost its appeal. We're going to be coming back in person.
We're just asking it be the same day as the co-defendant. Ms. Wilson just has too many stressors in her life, and at this point, we'll have to continue to learn to properly direct whatever kind of excess energy she has. And that's just going to be a process. But I would ask at this point in that she's very, very, very upset at the entire situation, not the court itself, but at the case that brings her to court, and some other things that are going on in her life. But that doesn't have anything to do with me. It doesn't have anything to do with this court. It does not put Ms. Wilson in a position to improperly direct her frustrations. But in order for the case to keep moving, I would ask that we have adjourned pretrial conference the same day as Ms. Haley.
I'm going to deny your motion, your request, but I will move the adjourn date till Tuesday, July the 25th.
Okay, we had jury trial that day.
I'm going to move the date to Tuesday, July 25th at 8:34. Ms. Silman, you're going to send a notice to Ms. Carter that we need counsel appointed for Ms. Wilson, and let Ms. Carter know that the proceeding is in person. Let Ruth Carter know that the proceeding is in person. As I previously indicated, failure to appear will result in a warrant being issued and the KP is being set, the bond being set at $5,000 cash surety plus a GPS tether. Anything further?
Judge, is the court requiring the complaining witness's presence on Tuesday?
No.
Okay, nothing further from the people, Judge. Thank you.
We have nothing on behalf of Ms. Wilson. Thank the court very much.
Now, Ms. Ritter, that's just because I'm adjourning today's proceeding, so it'll proceed as though it was today.
Understood, Judge. Thank you.
All right, then we're all set. Have a great day and stay safe.
This isn't just a wallet, it's a rare find. There's something different about owning something almost nobody else has. That's why when
Okay, I'm ready on Uriel, and then Ms. Uriel, I believe I gave you instructions about remaining stationary, but I may not have. So I need you to be stationary. I need you to be seated in an upright position and ready to attend court. I cannot walk around on your camera. You're standing at the podium right now. We're standing at the podium. Yeah, I'm frustrated too. Can you put your head up, take your hands off your eyes, and let's pretend that we're in court. If we can't pretend that we're in court physically, then we shall be in court physically. So we either have to pretend that we're there and act as if we're there, or we shall be there. We shall actually be there in person, standing at that podium. This is case number 224557001. The people of the state of Michigan versus Sierra Renee Urell. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
For the record, Your Honor, Joseph Pernicano, P84918, appearing on behalf of Sierra Urell.
Ms. Urell, please unmute and state your name.
Sierra Urell.
What's your middle name, please?
Renee.
Do we need an adjournment, counsel? Or I don't know, it seems like your client is quite frustrated for some reason unknown to me. We just called the case, like we literally only called the case.
Sierra Renee Urell.
I was talking to counsel. Counsel,
yes,
did we need adjournment? Did you need to talk to your client? I'm not real sure. How are you proceeding today? Because I'm not going to proceed like with hostility. That's how stuff go left, and then stuff goes left. Sometimes it's just better to be in person, because then people I don't know, they act a little better, maybe they act a little less hostile. I don't know, counsel, but how are we proceeding today?
Is it possible for me to have a breakout room with Ms. Urell? If not, then we would ask for an adjournment for an in-person hearing.
You can have a breakout with her. Did you know? You can have a breakout with your client for sure. And then
okay.
That'll also give Mr. Haddad an opportunity now to talk to the prosecutor, because he wanted to talk to the prosecutor. Did you know how you were proceeding with respect to your client, or you?
I lost contact.
Let me just let you talk to her. Okay, that sounds good. I'll let you talk to her. Oh, I think my clerk had told me that somebody wanted to do that with their client. All right,
yeah,
I'm going to send you. Okay, I'll send you and your client to breakout room number 15. Okay, I'm ready on Urell. This is case number 224557001. The people of the state of Michigan versus Sierra Renee Urell. Oh, this is a recall because I called it before. Okay, counsel, you've had an opportunity to speak with your client. How do you wish to proceed?
Yes, Judge. At this time, would you entertain a motion to withdraw?
I guess so.
Judge, there has been a
Go ahead.
I proceed. Thank you. There has been a breakdown in the attorney-client relationship. We have fundamental differences regarding our understanding of the facts in this case, as well as the application of the law to the facts. Based on that, I would motion to withdraw at this time, again, as there has been a breakdown in the attorney-client relationship.
And Ms. Urell, do you agree with that assessment by your counsel?
I guess.
Okay, I guess. And then counsel, you were retained, correct?
No, Judge, I am appointed on this matter.
Oh, okay. You're appointed.
Yes, Judge.
So does that mean that, oh, let me get Ms. Stevenson. Hold on. Give me 1 second. Ms. Ritter, can you join me and Ms. Stevenson in breakout room number 1? And then counsel, I may need you also, but give me a moment. Ms. Ritter,
Yes, Judge.
me and Ms. Stevenson in breakout room number 1.
Yes, ma'am.
So I had an opportunity. I was trying to figure out, after you said you were appointed counsel, I was trying to figure out why you would have been appointed, because we have, defender's office. And so that's why I went in to speak with Ms. Stevenson. And then she brought it back to my remembrance. So I'm getting ready to say this to Ms. Urell. You're going to find yourself in a situation where you're going to be representing yourself, because Mr. Pernicano is the second lawyer that I've had appointed to you. Miss Urell, I need you to look at me, because you're looking up in the ceiling. So this Mr. Pernicano is the second lawyer that I've had appointed to you. And the only way that we do apple picking when it comes to picking lawyers is when we hire our own lawyers. So when you hire your own lawyer, then you get to decide what lawyer you want. You get your lawyer of your choosing. And then I was reminded that your mouth was foul when it came to your lawyer. And people don't have to put up with people being disrespectful and rude and whatever.
If you live in an Alabama zip code and have 0 DUIs in the last 5 years,
again, you're looking up in the ceiling. And I'm trying to be patient this morning. People don't have to put up with being cursed at when they're trying to represent you. People don't. And I think you just cursed at me because I'm good at reading.
No, I did not. You were just trying to start something. I did not just curse at you.
You said I'm trying to start something, girl. Who you talking to?
Look at you. You're being rude right now. I'm not even being rude to you. You've been rude all morning. I haven't even been rude to you.
My level best. I've tried my level best. And then she just had the nerve to say I've been rude all morning. She just said I've been rude all morning. I mean, that is so hilariously funny. I can't even put that to words. So what I'm going to do is this. We're going to all just come on in downtown. And then I won't even have to read lips. I won't have to. I mean, I've literally not, she said I've been rude all morning. I've literally not said anything about the fact
I just tell you what you said.
So, I've literally not said anything about the fact that Miss Urell is like literally in the bed. I've not even addressed the fact that she's in the bed, and she said I've been rude all morning. And then thankfully, I don't care if you're sitting up. It is inappropriate to come to court sitting up, laying down, sitting over the bed. I don't care if you're sitting up. I know you're sitting up. I can clearly see with my eyes that you are sitting up, because contrary to popular, to your belief, because not popular belief, I'm very intelligent. I can see that you're sitting up in the bed. What I also know is that you have been rude and you cannot maintain a lawyer. I'm not inclined. So here's the situation we find ourselves in right now as you keep on talking, right? And the only reason that we can't hear you and it's not a disruption currently to the record is because you were on mute, and in this moment the court is not going to allow you to unmute yourself. So here's the situation. I don't have to keep giving you a lawyer. You're confused in your thinking. I have given you 2 lawyers free. I've given them to you. I've provided them as according to what the law requires. And this is the second lawyer that the court has provided for you that wants to withdraw. It's the second lawyer. So here's the situation. I'm going to allow counsel to withdraw. And then Ms. Urell is going to have to try to get her some more counsel. Ms. Urell is going to have to get her own counsel. Or Ms. Urell is going to have to represent herself. I will talk to the Michigan Indigent Defense Counsel office and see if they're willing to appoint one more lawyer for Ms. Urell. And I believe the answer may be no, because what we're not going to do is keep appointing lawyers for Ms. Urell to curse out or be rude to or decide that she knows best on how to do the case. That sounds like Ms. Urell needs to represent herself because she believes that she knows best how to do that. So we're going to come in person. Mr. Flanagan, we'll talk about it after the docket, but Ms. Urell needs to try to see if she can hire her own lawyer. If the MIDC appoints another lawyer to this case, and let me just let the record reflect. I know it can only be reflected in the video as opposed to in the verbal record because Ms. Urell is on mute. She is slamming her hands together. She is continuously talking while the court is talking. She is slamming her hands together. She now has her hands on her head, you know, and it's just inappropriate. So we're going to come in person in 2 weeks, and we're going to see if we can get another lawyer to do the case. And if not, that's fine too. Ms. Urell, today is January 17th. We're going to come January 3rd.
Being disrespectful in court is not going to go your way. When you come to court, if it's in Zoom or in person, you need to dress appropriately and you need to act appropriately. These judges do not play. They will lock your ass up. Because that's considered contempt of court.
31st in person. So we're going to set this in person at 9:02. Counsel, you are let the record reflect that Ms. Urell does have her hand up, and I am going to allow for her to unmute, but I'm going to state in advance and for the record that if you are rude, if you are yelling, if you are anything other than, and then let the record reflect that she is also sent directly to me, which is inappropriate, right? She has sent a chat saying, so I'm trying to figure out, you just not go let me say none, N-U-N. So that's what's in the chat. So let me just indicate for the record that is inappropriate to say to the judge. That's it's disrespectful. And if that's how you're going to talk to me, when I unmute you, I'm going to immediately mute you back. And then it appears that we might need to submit the matter for a competency evaluation, but I'm going to allow you to unmute and you're going to be respectful to me, or I'm going to mute you back. And there's nothing funny going on in my courtroom. There's nothing funny. So again, if we're not going to be respectful, then we're going to go back on mute. Okay, so you can unmute yourself, Miss Urel.
I could talk now.
Miss Urel, what do you want to
I
say
just
to the
asked, could
court?
I speak? And you just looked around and didn't say anything.
Miss Urel, what do you want to say to the court? This is my last time asking you.
Stop buying generic Viagra. If you're over 60, you qualify for 9 tablets of 100 milligrams.
Okay, what I want to say to the court is how y'all just go off of what some lawyer saying. You ain't asked me not one question. You ain't asked me nothing. You ain't asked me nothing.
First of all, lower your voice because you're yelling at me.
Because
Second
you
of
sitting
all,
here trying to make it just off of what a lawyer said.
First of
I
all,
was
you're
never
yelling at me,
disrespecting him.
and I'm not going to allow that. Second of all, I specifically said, so let's rewind.
No, I know exactly what you said.
Because your memory your memory is failing you, and let the record reflect that I've muted Ms. Sherelle. So when counsel asked to withdraw, I specifically said, Ms. Urel, do you agree with that assessment? So you said, I didn't ask you nothing. You said, I'm just going by what some lawyer said. And when counsel asked to withdraw, I specifically said, Ms. Urel, do you agree with that assessment? And then Ms. Urel said, I guess so. That's what Ms. Urel said. So let the record be clear that I, in fact, asked Ms. Urel if she agreed with the assessment. So I'm going to go ahead and set the matter for January the 31st for a final pretrial conference. It is in person at 9:02. We are going to contact the Michigan Indigent Defense Council to see if they will appoint a third lawyer for Ms. Urel. This will be the third and final lawyer appointed. If this relationship does not work out for Ms. Urel, then we are going to, let me disable the chat because Ms. Urel continues to speak to me in the chat, which is inappropriate. So I'm going to disable the chat. And then we are going to, Ms. Urel, if you would stop yelling, if you would pay attention, then I would take you off mute. But like literally right now, you're yelling, literally. And the only reason that we can't hear is because you're off mute. Now, what I'm going to do, let me just read for the record what she sent to me directly in the chat, which was inappropriate. Can you let me know if you're going to let the record reflect that she's clearly, like, she's, even in this moment when I'm trying to read what she wrote in the chat, she's literally yelling. But the only reason we can't hear her is because she's on mute. So she chatted me, and Madam Prosecutor, and her chat says, can you let me know if you're going to lock me up? No, okay. No, KNOW. So I can get my babysitter in order. Now, what's interesting to me is that I've not said anything about locking anybody up. We're coming in like I'm literally trying to get Miss well, let me say this to you. So you can unmute, because what's going to happen is if you keep cursing at me, what's going to happen is you are going to get locked up. Now, it's
that's
not
your goal anyways. That's your game plan anyways.
You don't know what my game plan is. You don't know anything about me. You don't know anything about me. So we're going to come in person January 31st at 9:02. We're going to contact the Michigan Indigent Defense Council, and we're also going to order a competency evaluation. So this is third lawyer. January 31st at 9:02 in person. Mr. Pernicano, you are discharged from the case. Everyone have a great day. Stay safe, and we'll see people on the 31st.
Thank you, Judge. Have a good day.
You as well.
Wix gives you the power of AI to build the website you need.
All right, Mr. McCreary, I'm ready.
I don't know how this stuff works. I'm new to this, so I'm
Okay, well, sir, hold on now. Are you okay? All right, this is case number 02-561-9901. The people of the state of Michigan versus Carnell McCreary. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pre-trial conference. And Mr. McCreary, your name?
Carnell Michael McCreary, ill, all lowercase, not the all caps corporation.
Nobody writes the name in all caps. All right. So today is the date set for a pre-trial conference. And Mr. McCreary, I understand that you are representing yourself. So how do you wish to proceed, sir?
First and foremost, if I may address the court and ask the court a few questions, with all due respect, may I speak?
I don't answer questions to counsel. I don't answer questions. That's not my role.
Well, I just wanted to say, you know, when I first came onto the Zoom, I felt that this court was disrespectful and restrained my First Amendment right to allocate myself here in this courtroom. And I'm not saying this as a personal attack, but that's just how I felt.
Hey, Mr. McCreary, all due respect, I'm not interested in your feelings, sir. I'm here to conduct court. So let's conduct court. How do you wish to proceed as it relates to your court matter?
I would like to challenge the plenary jurisdiction of this court as outlined by state Supreme Court.
Today is not the date for a motion. If you would like to file a motion with the court, I can give you a motion hearing date. But otherwise, I want to know as it relates to this pre-trial conference where you've indicated that you want to represent yourself, it is your responsibility to understand the rules of court and how to represent yourself. Today is only the date set for a pre-trial conference. As it relates to the pre-trial conference, how do you wish to proceed?
Well, if I may speak without being restrained again by the court.
You're going to be restrained every time you go off course. So
well,
understand every time you go off course, you're going to be restrained. You're going to be restrained in the same way that I would restrain any other person, any other lawyer, any other person who's not coming to court and addressing the court in the way that you're supposed to address the court for the pre-trial conference. So I'm asking you, Mr. McCreary, as it relates to the pre-trial conference, how do you wish to proceed?
I would like to ask that this court remove itself under MCR 2.003 for judicial bias. And once this
motion is denied, anything further?
Well, I would like to have it sent to the chief judge as required by the rule.
Mr. Flanagan, please call the chief judge and let him know that there's a request for recusal by Mr. McCreary and ask him how does he wish to proceed with the hearing for Mr. McCreary.
Yes, Your Honor. In code of judicial conduct, judge, and I haven't been
doing this for 16 years. I know what I'm supposed to do. So, Mr. McCreary, I'm addressing Mr. McCreary. I'm addressing your request on the recusal. So everything else, we're going to stop talking until I hear from the chief judge as to whether he wants you to come now or if he's going to give you a date.
Okay.
Thank you.
The rule, man.
Okay, thank you, Mr. McCreary. Thank you, Mr. McCreary.
Yes, ma'am.
Your Honor?
Yes, sir.
They indicated that he would need to file a motion for recusal before you, and if you deny that, it then goes to the chief judge.
He already
Well,
did. I accepted his oral motion. I denied it. So tell them it's denied. I'm not requiring him to file a written motion. The court rules don't require a written motion.
correct.
He requested thank you for affirmation, but I don't need it. He requested the recusal and I denied it. So ask them how do they want to proceed. I can sign an order of denial if they want me to just do an order of denial, but I've denied the recusal request.
Yes, Your Honor, the order of denial needs to be signed.
And then they're going to give him a date. In past times, some chief judges take the matter up immediately. So I just want to know, do they want me to give them a date?
Okay. Your Honor, no date. They said just sign the order and we'll bring it up. They'll contact them for a date.
All right. So, Mr. McQuarrie, please contact my courtroom. Make sure that my clerk has your current contact information. And apparently the chief judge's office is going to contact you with respect to your request for recusal. I will sign an order denying your request and then forward that to the chief. Okay?
Who do my call? The clerk? What is the number?
Sir, if you just, I promise you, I've been on the bench for 16 years, and I promise you, if you just let me talk, everything you want to know will be revealed. I promise you. Okay. So as I was saying, you're going to contact my courtroom and you will speak with the clerk. Make sure the clerk has your current contact information so that the chief judge's office can contact you with respect to your hearing on my denial of your request for recusal. Anything further with respect to this matter? Please don't unmute. Who is saying hello?
At Wayfair, we bring style to every get-together. They brought wings.
You mean these wingback chairs? Dive in, everyone.
Oh, can I speak or no?
Oh, well, what else is there, Mr. McQuarrie?
I would like to just say this, Judge. I have nothing personal with you. It's just that
Mr. McQuarrie, I don't take things personally. Ms. McQuarrie, let me say something to you. So since we're talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say that this case is from 2002. And maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However, we're going to proceed in the manner that you wish to proceed. So I'm not going to keep going on because you've asked me to recuse myself. I have denied the recusal. You have requested an appeal. I have granted that appeal, and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about, I don't take things personal. Why would I take things personal?
I take it personal because as a black man, a 50-year-old man.
This has nothing to do with you being a 50-year-old black man. This has anything to do with you being a defendant in the courtroom. Is there any legal thing for the record? Is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the appropriate parties, but I'm not. All right, so I'm going to assume that this matter, as it relates to the pretrial conference for Mr. McQuarrie, is concluded, unless there's something for the record on behalf of the people.
No, Judge, thank you.
All right, then, sir, you're all set. You have a great day, and you stay safe.
Oh, yeah. I would like to just say this, Judge. I have nothing personal with you. It's just that
Mr. McQuarrie, I don't take things personally. Ms. McQuarrie, let me say something to you. So since we're talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say that this case is from 2002. And maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However, However, we're going to proceed in the manner that you wish to proceed. And so I'm not going to keep going on because you've asked me to recuse myself. I have denied the recusal. You have requested an appeal. I have granted that appeal, and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about, I don't take things personal. Why would I take things personal?
I take it personal because as a black man, a 50-year-old man.
This has nothing to do with you being a 50-year-old black man. This has anything to do with you being a defendant in this courtroom. Is there any legal thing for the record? Is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the appropriate parties, but I'm not. All right, so I'm going to assume that this matter, as it relates to the pretrial conference for Mr. McQuarrie, is concluded, unless there's something for the record on behalf of the people.
No, Judge, thank you.
All right, then, sir, you're all set. You have a great day, and you stay safe.
Okay.
Call the case, please.
Calling case 02056199901. People of the state of Michigan versus Carnell McQuarrie L. Today is the day and time for a motion hearing.
Appearances.
Good morning, Your Honor, and to your staff, Christina Ritter on behalf of the people, P number 83505.
Sir.
Carnell Michael McQuarrie appearing in appropriate persona.
Okay. All right. To my understanding, sir, you filed a motion to have Judge Bryant disqualified from the case. Judge Bryant denied your motion, and essentially your motion was appealed up to the chief judge, which is me. Is that correct, sir?
That's correct.
Okay. Argument.
Well, the argument is, sir, under Michigan Code of Judicial Conduct, the judge is in violation of Canon 1 and 2 because I'm here falsely accused for a 21-year-old warrant. And I tried to speak, and she acts like Judge Judy. She just constantly cuts you off, is threatening, so far as be quiet. Like, I mean, Canon 2, it says public confidence in the judiciary is eroded by irresponsible and improper conduct by judges. A judge must avoid all impropriety and appearance of impropriety. A judge must expect to be the subject of constant public scrutiny. A judge must therefore accept restrictions on conduct that might be viewed as burdensome by the ordinary citizen and should do so freely and willingly, Judge. And I come into court very respectful. I'm a 51-year-old man and I respect the system. But I'm feeling that I'm being given, disrespect. I'm being silenced. I mean, I have a right under the free speech to petition the court for redress of grievances and things of that nature. And if you look at the TV show Judge Judy, this is how she acts, Judge. And I mean, it's just totally wrong. And she asked me, what did I want to do with the case? I said, I would like to challenge jurisdiction because I went to prison in 2002 for 15 years and 8 months. They had under the rule, it's, I believe, for misdemeanors, 40-something days, for felonies, it's 6 months. So I request that the prosecutor prove its authority in bringing these charges so late. And I have been home 6.5 years, productive in the community, no problems. And I'm trying to do right, Judge. I made past mistakes when I was a young man. And I'm just being treated like I'm just a criminal. I'm supposed to be innocent until proven guilty, right? So I'm not trying to disrupt this court. I'm not trying to cause you guys hardships or anything, things of that nature. And my due process is being violated, Judge. That's all. I want to just get this case so it wouldn't be left alone. I'm a grandfather. I have children. And their DPD has retaliated against me, Judge. And I know this is a Detroit police court. And I would like an investigation as to things that's been going on by the prosecutor's office, because Kim Worthy and her subordinates are retaliating against me. There's actual proof. At this point, I don't know if you're familiar with Bill Proctor. He's representing me in this matter and another matter so far as investigations for years of, hardships and tyranny committed against me by the system here in Wayne County. So this is all I want, a fair shake judge, a judge who's going to give me due process and give me what I'm entitled to according to law. And that's it, sir.
Okay.
No offense, but if you're paying more than $50 per month on home insurance, you're literally throwing money away in the trash. Seriously.
Ms. Ritter, would you like to respond in any way?
Judge, the only response that people have is that this is a case from 2002. It's a misdemeanor assault and battery case. Judge, from my recollection of the prior hearing with Judge Bryant, I do believe, if I'm not mistaken, that it was an arraignment process. And as the court was trying to proceed with the process, I do remember Mr. McCreary interrupting the judge while she was trying to make the record. But the people have not gotten to the point where, because Mr. Carnell was disruptive during the proceedings, the people didn't get to the point where there was another pretrial date set where the people could actually see if we're able to move forward in this 2002 case, Judge.
Okay.
I have a rebuttal.
Yes.
Okay, Judge, I would like you, if it's possible, I know you guys are on Zoom, so you should have access to recordings of these hearings and things of that nature. I believe that the prosecutor just fabricated facts to you because I was not rude to this lady. All I asked her is, like, she said, what do you want to be done with this case? I said, I would like to challenge jurisdiction. And Michigan and federal law requires once jurisdiction is challenged, it must be proven. How is it that the prosecutor knows statute of limitations? They're licensed. I'm not licensed. I've studied for years in prison. And they don't know that there's a statute of limitations. This is vindictive prosecution because of my complaints against Kim Worthy, Your Honor. And the record will reflect the evidence. And I object to her statements.
Okay. One second. One second, sir. I have to shut off my video for 10 seconds and be right back. I'm having a little technical difficulty right now. So.
Yes.
All right. Court having had a chance to hear the arguments of the moving party, as well as the arguments of the prosecutor. The moving party is asking for a recusal or to have Judge Bryant disqualified based on Michigan Canons 1 and 2, based on that she is biased, as well as is not allowing a person to be able to basically argue their case. The moving party is stating that he wants to challenge jurisdiction and that he was not allowed to do so. The prosecutor is stating that there was only a proceeding at an arraignment and that the prosecution hasn't even got to the point where they have established whether they want to move forward with the case, but that was not allowed to happen because in their view, there was disruption in the court and there was a breakdown. The moving party is disputing that. He's saying that that I could go to the video with tapes to dispute that. At this time, the court is not going to make a decision at this point. I am going to pull the tape, pull the transcript. I'm going to make a decision very quickly on this. I'm not going to let this continue. And even based on, the court does have an opinion probably on the likelihood of prosecution on a 21-year-old case. So we're going to come back on, we're going to come back on July 6th at 10 a.m. Please check your schedule, sir.
May I also, you say July 6th, sir?
Yeah.
Okay.
Yes.
May I also, if I may, Judge?
Check your schedule first. Check your schedule to see are you available for that time.
I'm available. I'm stuck here on tether, sir. I'm available at any time you guys want me to.
Okay. All right. Well, put it on your schedule for 10 o'clock on July 6th.
Okay. Can I say one more thing? If you look at Crampton versus Michigan Department of State 395, Michigan 347 at 351, it says the United States Supreme Court disqualified judges and decision makers without a showing of actual bias in situations where experience teaches that the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. And I'm not saying like trying to attack Judge Bryant or whatever else, but she has an attitude like Judge Judy. She just cuts you off, and I'm just like, so when she kept doing it, this is when I objected and asked her to recuse herself, sir. But I won't.
And sir, and again, as the chief judge, I don't have to have a showing of actual bias, but perceived bias, something in the fairness of justice. That is my standard. So with that being said, 10 a.m. on July 6th. I'm just going to.
Drinking warm water before bed improves eyesight almost overnight. Thousands of people are already.
Good morning, Mr. Williams. That's going to be my last attempt because it is 11:56. Mr. Williams was scheduled this morning at 10:30, and it's 11:56, just in case you didn't know. Mr. Williams was scheduled this morning at 10:30. It's 11:56. Okay, we'll put him in a breakout room. It's 11:56. It's 11:56. Okay.
I don't need a breakout room from Mr. Williams.
You should, because you should.
Okay.
That the judge might not even hear your case this morning because it's 11:56. It's 11:56. He was scheduled at 10:30. So you might want to ask him, why is he just coming in my courtroom at 11:56? Hmm. 234416301. The People versus April Marie Hollins. Defendant is charged with 1 count of guns, possessing while operating under the influence, and today is the date set for sentencing. Appearances, please.
Good morning, Your Honor. May it please the court, Thea Burton appearing on behalf of the people.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. April Hollins. Ms. Hollins, ma'am, will you please say your first, middle, and last name?
Morning, April Marie Hollins. Today is the day set for sentencing. On behalf of the people, are there any additions, deletions, or corrections to the pre-sentence report?
No, Your Honor.
On behalf of the defense, are there any additions, deletions, or corrections?
Your Honor, on behalf of Ms. Hollins, we've had the opportunity to review the pre-sentence investigation report. Judge, can you give me just a second? I'm having a problem with the iPad. On behalf of Ms. Hollins, Your Honor, we've had the opportunity to review the pre-sentence investigation report. We did find it to be factually correct. We have no additions or deletions at this time. Ms. Hollins does stand ready for sentencing.
On behalf of the people, anything as to sentencing?
Your Honor, the only concern the people have is that Ms. Hollis submitted to a analysis that was positive for drugs and alcohol, marijuana and alcohol. And so that is a concern considering this particular offense involved alcohol. Other than that, the probation department has recommended or submitted a fair recommendation, and we'd ask the court to adopt it.
Ms. Stevenson?
So, Your Honor, we want to, when I happened to be down at the probation department on the date that Ms. Hollins started her pre-sentence investigation, and she had to go do her urinalysis, and she was like, I didn't know I wasn't supposed to drink.
She's not being honest. She's not being honest.
So I looked at it again today, and I did advise her. I'm like, okay, I don't think it's true that you didn't know. I do think it's true that you forgot, because the order was given. I think we've been moving through this case for about a year, but I said that just to say, so that the court could know that Ms. Hollins was at least doing what she could do. She wanted me to come talk to you about it on the date that she went to the PSI interview. She just was trying to be upfront, and that's the reason I brought that to the court's attention. So Ms. Hollins, I did asked her about her source of income. And she said that she used to work as security, and she's trying to get back into that field at this time. If she can't get a job doing security, then she's trying to get a job doing retail work. But she gets food assistance. That's the only other source of income that she has. So at first I was looking at the community service recommendation from the probation department, and I thought that that was a little bit excessive. I've changed my mind on that because, I think that the court did remind us that somebody in this courtroom mentioned that sometimes when people do community service, that turns into a job. And I think that that would be very helpful for Ms. Hollins. So, the charge that she's here for is that she is in possession of a firearm under the influence. We don't have anything like that reoccurring since the time she started coming to court on this case. She's been here. She's been in communication with me. She doesn't have any prior criminal history. She's not trying to avoid any responsibility in this case. She knows that she's probably facing an advanced sanction because of consuming alcohol while she was on probation. But I do believe, despite that, Your Honor, that Ms. Hollins knows how to follow directions, and she intends to do that so that she can move past this. And so I'm asking the court to follow the probation department's sentencing recommendation. Place her on a term of probation with which I believe she will speedily comply. Let her move forward with her life, Your Honor.
I put this in my ears, and I haven't asked anyone to repeat themselves in over 3 months. This is magic.
All right, would she like to address the court?
Ms. Hollins?
Yes, ma'am. I do understand that of my sentencing today, and I am willing to fully cooperate with the courts and the probation to move on and succeed in a timely manner with my probation.
Court is ready to impose sentence. I do so as follows. The probation department has recommended a term of probation of 12 months. I'm going to accept the recommendation for probation. However, the term of probation is 15 months with a final review date of January 14, 2026, an interim review date of February the 12th, 2025 at 10:00 a.m. The terms of the probation are as follows. You shall not violate any criminal law of any governmental unit. You must not leave the state without consent of the court. You must make a truthful report to probation on a monthly basis and notify probation immediately of any change of address, phone number, or employment status. You will pay the following fines, costs, and fees. The mandatory cost of $210, $100 attorney's fee, $400 fine, $525 oversight fees. That is at a rate of $35 a month. For the halfway point, it would be $263. A $100 assessment fee. Court is not going to impose the urinalysis fees, but that's because she can test outside the court if she was testing outside the court. And then the total fines, costs, and fees, not including any urinalysis or classes, is $1,335. For the halfway point, it would be $1,073. Additionally, you shall not use or possess any illegal substances. You cannot use or possess any marijuana without a valid medical marijuana card. You cannot use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not consume alcohol in any form. You shall not drive without a valid driver's license. You shall not use or possess any handguns or firearms. You shall attend alcohol highway safety education level 1. You shall submit to random urinalysis twice per month. You shall attend outpatient treatment, Alcoholics Anonymous. You will complete 10 days of community service. That's equivalent to 80 hours of community service. You will attend the Victims Impact Panel, watch the consequences video. You will pay outstanding tickets that you owe with the 36th District Court. You will clear up all warrants that you have. You will attend the Choices program. Your first date, as I indicated, is February 12th, 2025 at 10 o'clock a.m. We will mail a copy of this order to the Crescent Drive address, and probation will contact you at the phone number ending in 8536. Anything further?
Nothing from the people.
Your Honor, we have heard the court's order, and absolutely Ms. Collins has indicated she intends to abide by the court order. I'm just, with regard to the alcohol highway safety education program, would the court be ordering that this was not a drinking and driving related offense?
She was had a gun while operating under influence. What are you saying?
I believe she was a passenger.
No, Your Honor.
Say that again.
I believe she was not operating a motor vehicle, Your Honor. There's no allegation that she was operating a motor vehicle.
Are we talking about, we're saying April Marie Hollins?
Yes, Your Honor. Is charged with being in possession of her firearm while under the influence.
I apologize. Can somebody tell me what O stands for? What does O stands for? So, because I'm looking at the docket. So when I called the case, nobody corrected the case. Also on the, well, it is maybe correct. It says possession under the influence on the thing. So when I called the case, nobody corrected the case. It's OUI. So I don't know. I don't have the thing. So this says gun possessing OUI, operating under the influence. Isn't that what that stands for?
I'm not sure what it stands for, but she's charged with weapons, firearm possession under the influence.
Mr. Flanagan, so can we change it then?
Oh, yes, Your Honor, that's what it is in the system. Weapons, firearms, possession under the influence.
So help me then. Why? Help me. That y'all not being honest. Help me with what is OUI on the docket then? Just tell me. Somebody tell me. Mr. Flanagan, tell. What is gun possession OUI? What is that?
Operating under influence.
I know. So it's in wrong then. So somebody put it in wrong. It couldn't be correct. Somebody put it in wrong. It's in wrong because it's OUI. That means operating. The O stands for operating under the influence. But okay. So the O shouldn't be there. It should be just gun possession under the influence. Okay. So therefore, I will take away the Victims Impact Panel and the consequences video and the Driver's Improvement Program. All right. And the alcohol highway safety.
Shop Granger. Talk shop for your shop. 1 million industrial grade products backed by.
See how 4 things come off because of that O? Okay. So that is okay. Let's correct it let's correct it. All right. She has 3 warrants with the 36th District Court, so she needs to clear those up right away. Oh, I did not order, but let me go back. So I am gonna add, I didn't add it, the handgun intervention. I will order that as recommended by the probation. So we're removing alcohol highway safety, we're removing victims impact panel, the consequences video and driver's improvement. Those are removed from my order. And then we are adding handgun intervention. All right, anything further?
From the people.
So, Your Honor, Ms. Collins does have a phone number for Judge Millhouse's courtroom, and she'll call them and get those warrants taken care of as soon as we get done in here today. Would the court consider outpatient treatment if there are any further positive tests rather than ordering that up front, Your Honor?
No.
Other than that, we have nothing further, Your Honor.
Okay. And let me just be clear as to why I'm not going to do that. I'm clear. When I speak, I'm clear. And yeah, when I speak, I'm clear. And so you can say she forgot and she can say she didn't know. But that also says to me then that she either didn't listen or didn't care. But I'm clear when I speak. So if it had been another judge that ordered that, maybe then I would say I can't guarantee that they told her. But I know that on at least 2 occasions, I said bond will continue, no drinking and no driving without a valid license. I say it. So we're going to go ahead and do outpatient treatment. And if the outpatient treatment people say that she doesn't need it, then I guess we'll go from there. But no, it's in the order.
Okay. Thank you, Your Honor.
All right, we're all set. Have a great day. Stay safe. Thank you. We're going to mail a copy of the order, if I didn't already say that, to the Crescent Drive address. And probation will contact you at the phone number ending in 8536. All right.
So, Judge, I need to go into the courtroom and talk to Mr. Lindsay and talk to Mr. Williams. Which of those should I do first?
No. Oh, I didn't mean to do that. Why? I didn't. Okay, they didn't report it to girl to Zoom. No, go do Lindsay.
Okay.
I'm ready. Where's Mr. Lindsay? All right, this is case number. Case number
Scammed by a broker? Lost your money? Don't wait. Every day of delay,
2062165001, the People versus Edmund Lindsay. Defendant is charged with license plate illegal use. Today is the date set for review. Appearances, please.
Janice Stevenson, appearing on behalf of Mr. Edmund Lindsay. Mr. Lindsay, sir, please say your first, middle, and last names.
Edmund Hampton Lindsay Jr.
All right, Ms. Stevenson.
So the court did adjourn the matter, Your Honor, from this past Friday for today for Mr. Lindsay to come to court in person, which he has done. The court did previously extend the probation to give Mr. Lindsay an opportunity to do community service in lieu of costs and fines. Your Honor, Mr. Lindsay has not, because of health conditions, been able to complete the community service. He did hear the court say, I believe it was on Friday, that there would be other community service opportunities available to him, which would not cause him to have to walk around, which he can't do because he has a hip injury.
I just seen him walking. What are you saying?
I have 2 broken hips, man.
I don't know who he's talking to, but what I'm saying to you, Miss Stevenson, is that I just saw him walking. I also know people who had 2 hip replacements, right? I don't see him on a cane, on a walker, in a wheelchair. Furthermore, I didn't say there would be opportunities available to him, because there's always been opportunities available to him. We have a thick book of places that have community service. So, okay, come on.
Yes, we do not represent to the court that Mr. Lindsay can't walk, Your Honor, but what he's indicated to me, and what I think he reported last week, is that because he's scheduled for the hip surgery, he did not understand that there were other opportunities that were available to him. Now, I did talk to him about the reason he didn't understand that, and I think it comes down to Mr. Lindsay not interacting with his supervising probation officer in the way.
You're talking about the probation meetings that he missed in July, August, and September.
And I think that's what's causing the disconnect for Mr. Lindsay, Your Honor. But I don't believe that Mr. Lindsay is trying to run from the court. I believe exactly the opposite. I think if Mr. Lindsay were trying just to totally disregard this court's authority, once he had a pretty bad hearing on Friday, once he could see where this is going, I don't think he would have made it down here. I don't think he would have stayed out in the hallway until about an hour ago. I don't think he would have kept knocking at my door trying to get my attention if he were not trying to handle this matter. So I don't think Mr. Lindsay's trying to run. He told me that his source of income is plasma donation. He does have children. He's using a bicycle when he can for transportation. So I'm not, the charge involved Mr. Lindsay doing something that I think is, kind of strange, that he doesn't go down to the Secretary of State and get his plate the way every lawful driver does. He did something different. Plate has to come from the Secretary of State and has to go on the card that they say it's supposed to go on. And he didn't do that. And he pled guilty to that. And that's what he's here for today, Judge. So
I know, and that's why it's a shame. That's why it's a shame if he has to go to jail. That would be his own doing. He's literally been on probation for 13 months. So now you tell me what you want me to do. He's literally been on probation for 13 months and still has to do the same thing he had to do 13 months ago that he has not done. So how much more grace and mercy? Come on. Just tell me.
Until the day that is the day there are no more. I don't know. I want grace and mercy to continuously flow. And
today is kind of the day that there are no more. But okay, sure, Ms. Stevenson. So 13, 14, 15, 16, 17, 18, 19, 20. And then that's 7, 8, 9, 10, 11. Okay, let's just go. Let's go. Let him go across the hall. You say he's not running, but he has 3 other warrants out for his arrest. You say he's not running from the law. You say the fact that he showed up means he's not running. Well, maybe he just got tired of running. He's been running. Maybe he just got tired of running.
But
Well,
hey,
I know
that's
he's
just
not running
Docket.
this court, and so he's not disregarding this court
Oh,
authority
okay.
to the rest of it, but he's here to face the music with you, Judge.
Okay, well, let's face the music again in January. Cause you want me, let's just keep facing me. Let's just keep dancing to the music. Okay. Until there's no more music to dance to. January 14th. He's gonna go across the hall today. He's gonna go see Miss Bumpus today. If he fails to see Miss Bumpus again, I'm not gonna do this. So it costs nothing to meet it with his probation officer. He doesn't have to use his legs. He doesn't have to, he can call her on the phone. He can do whatever. Listen, okay, January the 14th, 10:02, in person. Anything further?
Not at this time. Thank you very much, Your Honor.
You're very welcome. All right, let's see if he'll go across the hall and talk to Ms. Bumpus today. All right, I'm ready on Williams, who was 2.5 hours late for court.
Stop buying generic Viagra. If you're over 60, you qualify for 9 tablets of 100.
But what I'm not going to do is continue to wait for Mr. Williams. Case number 194604201, the People versus Dedrick Anthony Williams. Defendant is charged with license plate illegal use. Today is the date set for trial. Appearances, please.
Good morning, Your Honor. May it please the court, Delphia Burton appearing on behalf of the people.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Dedrick Williams. Mr. Williams, sir, please say your first, middle, and last names.
Ms. Stevenson, what are we doing here? He was 2.5 hours late for court. I'm sorry. Late for court.
Say your first, middle, and last names, Mr. Williams.
Dedrick Anthony Williams. I'm sorry, I couldn't hear you, man.
All right. Today is the date set for trial. Are the people ready to proceed?
Yeah, no, unfortunately, the people are not able to move forward on this matter. There was the case was supposed to be reassigned because the officer in charge was not no longer there.
Oh, okay.
And yeah, subpoenas were sent to involve the use of a yellow plate. That was the allegation, and it's from 2019, and so we're not able to move forward.
Your Honor, we would apologize to the court for our tardiness. Unfortunately, Mr. Williams found himself arrested and had to walk from the jail. He's back at home now trying to get to the urgent care. We would move for dismissal, Your Honor.
All right, the court is going to grant defense counsel's motion to dismiss as the people are unable to proceed. Today is the date set for trial. The witnesses have not appeared, and it is 12:34. We will mail a copy of the order of dismissal to you for your records. Anything further with respect to Mr. Williams?
Nothing from the people.
Nothing on behalf of Mr. Williams. Thank you, Your Honor.
All right, Mr. Williams, I hope you feel better. Have a great day. Stay safe.
You too, man. I'm sorry for being late.
I accept your apology. Sound like you had a decent reason.
I did, man.
All right. All right. Bye, Ms. Stevenson. You brought me out that day.
There's always.
I don't know what time they wanted to bring Mr. Lake, but they'll have to try again tomorrow. All right.
Okay.
Judge Jefferson.
Right now.
No, he was. It was dismissed. It was a pre-trial scheduled for Judge Garrett on October 28th.
Well, I mean, was he downstairs?
No, I'll bring him tomorrow.
Okay.
When I called down there, Your Honor, he wasn't down there, but he did have an exam before Judge Jefferson this morning. The felony charges were dismissed and the pretrial was set for Judge Garrett, October 28th.
Judge Garrett?
Yes, it was domestic violence.
Oh, okay. Well, they didn't want to bring him to me after he finished his exam. So we'll see what happens tomorrow. All right, everybody have a great day and stay safe.
I'm telling you about something that's gonna change your life. I had so much pain in my knees.
Except for review, and apparently Mr. Floyd has been assigned a new probation officer who is not present today, and I did not receive an update from Ms. Bryson. However, let's see if the register is going to tell me something. So until Mr. Flanagan is going to send me the register of action, but Ms. Hall, what, Mr. Floyd, can you come into the screen, sir?
Oh, yeah. There you go. Okay, there we go.
Okay, thank you. Ms. Hall?
Your Honor, it's my understanding that Mr. Floyd has actually completed all of the requirements imposed by this court to complete probation.
Let's see. Mr. Flanagan,
Yes, Your Honor.
did you receive a request for a probation discharge on Mr. Floyd?
No, Your Honor.
Then perhaps probation doesn't agree with the assessment that he has completed the terms and conditions of the probation. But let's try. Mr. Flanagan, I know I told you don't worry about calling Mr. Farmer back, but can you try?
Yes, ma'am.
Oh, let's see. Maybe there's something that they have that will help us. So it looks like Mr. Floyd was placed on probation by me back in April of 2023. He was ordered to complete the victim's impact panel, watch the consequences video, attend the alcohol highway safety. He was ordered to submit to urinalysis and pay $11.30. So, whoops. First of all, let's see. So he does have a zero balance according to the Register of Action. I'm having a hard time with Mr. Floyd's camera angle. I'm having a hard time with it. All right, so we're going to try to see if we can confirm that he completed the terms and conditions of the probation so he doesn't have to come back. If he has, he would have completed over half of the probationary period. So let's see if I can get a response from Mr. Farmer. Oh, order for, I hate when I don't, okay, try to call Mr. Schiotti. Try to call Mr. Schiotti for me and see if he can either, if he can find Mr. Farmer or look for it. And then hold on a pair of seconds. Hold on 1 second.
Well, let me read the case now.
Oh, no, that's fine if they're going to do it. Thank you. Okay. So let's just wait a moment for the call back from Mr. Farmer. Ms. Hall, you're not ready on Boyd. Are you ready on Boyd?
Yes, Your Honor.
Oh, okay. Well, then let's switch over to Boyd. This is case number 214433001, the People versus Brian O'Neill Boyd. Defendant is charged with operating with a high BAC, driver with open intoxicant in a motor vehicle. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. Rakidia Hall on behalf of Brian Boyd. Sir, may you unmute yourself and state your full name for the record? You're muted.
I got it. Brian O'Neill Boyd.
You're muted, Judge.
Today is the day set for final pretrial conference. How are we proceeding?
Mr. Boyd would like to continue his not guilty plea and set this matter for a for a jury trial.
The court continues a not guilty plea on behalf of Mr. Brian Boyd, set the matter for jury trial. Mr. Flanagan, can you go to August 26th, please?
Yes, Your Honor.
Do I have any?
Nothing on that day.
All right, the court is going to set the matter for August the 26th with the final pretrial conference, August the 16th at 9:10. Anything further?
No, thank you, Your Honor. Nothing further, Mr. Boyd.
All right then, Mr. Boyd, you're all set. Have a great day. Stay safe, and I'll see you August the 16th at 9:10 on Zoom.
Okay. Have a great day.
All right. Thank you.
Bye.
All right. With respect to Mr. Floyd, Mr. Farmer is looking up the notes, so I should have an answer shortly, and we'll see if probation agrees with Mr. Floyd that he has completed the terms and conditions. So let's go on a few minute break, and I'll see if Mr. Farmer can pull up those notes. Okay.
Thank you.
All right. You're welcome. All right. We're back on the record with Mr. Floyd, and I did receive something from probation. Let's see here. According to Mr. Farmer, Mr. Floyd did not do the victim's impact panel, and he has failed to test several times for the last several months. That's what Ms. Stevenson, maybe you should put your appearance on since Ms. Hall was the one doing it before.
Okay. For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Kenneth Floyd.
If you're currently using or planning to use any of these companies and you can see your car listed here, then you should go with this.
All right. So Ms. Hall said that Mr. Floyd said that he had completed. Mr. Floyd, please sit up for court. Just sit up straight for court for me. That Mr. Floyd said he had completed all the terms and conditions. So I hunted down probation. His probation officer is Ms. Bryson, but she's not here today. So Mr. Farmer sent the court an update indicating that what did I just do with the update? Hold on. Indicating that Mr. Floyd still needs to complete the victim's impact panel, and he has failed to test for several months, and they say they submitted a violation to me, but I don't, when I put this in my search engine, I didn't see any violation requests submitted, but they said they submitted a violation previously. So did you all need to speak to Mr. Floyd about the fact that he is failing to test on an OWI case, and his failure to test means that he's tested positive on however many times he did not test, and that is a violation of his probation?
Yes, I would.
Go ahead.
Yes, I would like an opportunity to talk with Mr. Floyd, Your Honor. But so does the court have a violation, or?
I didn't see it when I it wasn't Google. When I searched my email, I didn't see it. Mr. Flanagan, is there a request in the file for a violation?
Yes, Your Honor, signed by Judge Baltimore.
Oh, see, it wasn't signed. I didn't know anything about it. When was he supposed to come for a violation? It doesn't say it on the docket. What court date was set for the violation?
It was set for December 5th.
Oh, I still wasn't here. So what happened on December 5th?
And on December 5th, Judge Austin Garrett scheduled it for today.
Oh, it's not reflected on the docket for today. It just says review. So apparently violation was supposed to be today, but it doesn't say violation hearing today. Okay, so he can go back to the breakout room, but.
Okay, so the alleged violation is failure to test.
Mr. Flanagan, can you send it to me and Ms. Stevenson?
Yes, Your Honor.
All right.
Thank you. Yes, Your Honor.
Okay, we're back on the record with case number 1-846-09601, the People versus Kenneth Raymond Floyd. Okay, so I have had an opportunity also to look at the initial request for the probation violation signed by Judge Baltimore. And it said that the defendant had stopped submitting to, wait a minute, what's this? What is this y'all just sent me, Mr. Flanagan?
That's to counter the violation.
Mr. Floyd had stopped submitting to your analysis, and had failed to provide proof of the alcohol safety class and the victim's impact panel, and that he has failed to report to probation. So, Ms. Stevenson.
So just to the emails that he could put his hands on quickly, Your Honor, show that that's not quite correct. We do have communications direct. Mr. Floyd advised me that he has been calling the probation department. He had been calling and not getting any response. And so my suggestion to him was that he stop calling and start emailing. And he did that. The court has 2 of the emails that he sent in January to Ms. Bryson as well as to Mr. Farmer. I think the court does have the email showing proof of having completed the alcohol highway safety education course. He emailed that directly, I think, to Mr. Farmer, also completing the victim's impact panel. And then even though he wasn't supposed to do this, according to Mr. Floyd, the drug testing agency told him they didn't want him sending that stuff, that they had to send it. And he's like, no, I need to get this directly to my probation officer myself because they're saying I don't do these tests. So he emailed those receipts of tests to Mr. Farmer. And I think he has some more, but just for the sake of, getting to this hearing, Mr. Floyd wants the court to know that that is part of the proof of that he has done what he knows how to do to contact the probation department by telephone and finally by email. And he has been going to urinalysis, and he did those counseling sessions, Your Honor, and provided proof of that to the probation department.
So, Mr. Flanagan, don't send that to me. Send that to Mr. Farmer.
Okay.
I'm not going to confirm anything in those emails.
I just wanted to, I didn't want to have any ex parte communication with the court, which is why I sent it to Mr. Clerk, Your Honor.
Mm-hmm.
From food grade lubricants to LED lighting and every product in.
So who was his probation officer? So all of a sudden they stopped communicating with him?
So that's part of the issue. He says that somehow he was able to find out that he should be with Mr. Farmer, possibly. And then he found out somehow that he should maybe be with Ms. Bryson. He said there's a third probation officer. Okay, Mr. Floyd, just relax. That's part of the issue, is he has not known who his probation officer is, Your Honor.
I mean, that's not the issue. He he was with Mr. Farmer, and then Mr. Farmer got promoted. It ain't no big mystery. He was with Mr. Farmer. Mr. Farmer got promoted. He got assigned to somebody else. It's not a big mystery.
But he says that there was another officer before Mr. Farmer.
Well, let's not act like this is not a 2018 case.
Yes.
Okay, so it's a 2018 case, and there is a possibility that he has had more than one probation officer, because this is a 2018 case. So what we know is that his last probation officer got promoted to supervisor. That was Mr. Farmer. And then Mr. Farmer apparently must have assigned it to Miss Bryson. And so now it's Miss Bryson. What I'm struggling with at this particular moment is the fact that Mr. Floyd just seems like he can't sit up straight for court. That's what I'm struggling with at this moment. So it looks like he has proof of some things that may have gone to Mr. Farmer, but should have gone to Miss Bryson because of the switch. I'm sure that as supervisor, Mr. Farmer is getting many more emails than he used to get. That's not an excuse for him not to have responded. So what we're going to do is Mr. Flanagan is going to submit those emails that you sent to me. Now, what you said, Ms. Stevenson, was that those are not all of the emails that he has, all of the receipts. So what I suggest that we just adjourn for a week. Ms. Bryson may have those things in her email. I don't know, but what I want to see is whether or not he has been submitting to the urinalysis, that he was submitting to the urinalysis at the time that Judge Baltimore originally signed for the probation violation order. Now he's almost up to his year, and they kept adjourning it, waiting on me to come. I guess nobody wanted to do it themselves. So I'll be satisfied and discharge him if those receipts are verified by Mr. Farmer or Ms. Bryson, and then we can go ahead and discharge him from probation. So we want to just adjourn it for a week? Because I don't know how long. He said he don't want to adjourn it for a week. Let's adjourn it till April.
That's actually, I think, what he was saying at this point. Just let it continue to the end, because he kind of keeps coming back.
Okay, well then, I mean, well, that's stupid, but go ahead, let's do it. I mean, I don't even need to look at it. If he want to keep paying for drug tests through April, if he want to keep going to drug tests through April, then let's go. No, well, stop shaking your head and things and such then. And let's do the case. You know, I don't come on here to play games. Now, Judge Baltimore signed the order in my absence. I wasn't here. He didn't have the hearing. Otherwise, I wouldn't have. I said it. Y'all don't pay attention half sometimes. Okay, I said it. Miss Bryson is not here. She's not here today.
Okay.
I don't know when she's coming back. I assume she might be on a week's vacation, as every person is entitled to who works a job. That's why I said adjourn it for 1 week.
Okay.
But we don't have
just
to.
looking at how
Mr.
long is the
Flanagan,
testing
what's the
been going
final
on?
review date?
April 10th.
We can adjourn it to April 10th, so nobody has to keep coming back.
So could we look at it in a week, Judge? I mean, he has been, initially it was charged with the high BAC. So as a bond condition, he's been testing for over a year now. And I don't know that I've seen any violations.
This is what's bothering me, and I'm just going to let you know what's bothering me.
Yes, Your Honor.
When I said adjourn it to a week, nobody wanted to adjourn it to a week, right? When I was going to squeeze Mr. Floyd in, he was shaking his head no. And then you said, well, he just prefer to come in April. Now I said in April, now everybody want me to adjourn it for a week.
Could we have a week, please, Judge?
Let's just have a week. Let's come back next week and we'll see what Ms. Bryson has to say.
Limu Limo at your service. Here to help you save hundreds by customizing your car insurance.
On behalf of Mr. Hunt.
Mr. Hunt, can you please state your full name for the court?
Anthony Lamont Hunt.
All right. Ms. Stevenson, this not working for me. Who spoke to Mr. Smith in the breakout room?
I'll get him back in there with Miss Rockman.
Okay, go back in. Let him go back in. All right. With respect to Mr. Hunt, today is the date set for pretrial conference. How are we proceeding? Mr. Moore, how are you proceeding today?
I contacted the prosecutor yesterday, and they said in my office operating while visibly impaired. If that's the case, we'll take that offer.
Okay, so your client wishes to enter into a plea today?
Yes, I advised him of his rights. I advised him of the possible penalties, and he like to waive those rights and plead guilty to operating while visibly impaired.
Ms. Ritter, is that the people's offer?
Judge, that is correct. That's the people's offer at this time.
All right. Mr. Hunt, you would like to accept the people's offer, sir?
Yes, Your Honor.
All right, Mr. Hunt, I am going to share my screen momentarily. And on my screen, you're going to see an advice of rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights? Sir, have you had, please have a seat, Mr. Hunt. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes, I did.
And when you did that, did you understand your constitutional rights?
Yes, I did.
Sir, do you understand that this is a misdemeanor and therefore you have a right to a trial? However, if I accept the plea from you today, drawing your attention to number 6 on the advice of rights form, do you understand that you will not have a trial of any kind if I accept this plea from you today?
Yes.
Sir, has anyone threatened you in any way or promised you anything that was not placed on the record today to get you to give up your right to a trial and enter into this plea?
No.
Are you currently, Ms. Stevenson? Oh, never mind. Are you currently on probation or parole?
No.
Finally, sir, the court draws your attention to number 11 on the advice of rights form. It indicates that an appeal to the circuit court may be taken within 21 days of the date of your sentencing. However, do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would have to either request permission of this court to set aside your plea or request permission of the circuit court to appeal the conviction.
Yes, I understand.
With that understanding, do you still want to give up your rights to trial and enter into a plea today?
Yes.
All right, sir, raise your right hand for me. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You may put your hand down. Who's going to voir dire Mr. Hunt with respect to the factual basis?
I can't judge if that's okay with the court and defense counsel.
Yes, sir, fine with me.
You may.
Thank you. Mr. Hunt, on June 17, 2022, were you operating a motor vehicle on northbound M10 Service Drive and West Grand Boulevard?
Yes, I was.
Is that the city of Detroit?
Yes.
Is that the county of Wayne?
Yes.
And
while operating a motor vehicle on North M10 Service Drive, well, strike that. Prior to operating a motor vehicle, did you consume any alcohol?
Yes.
And did
Not-
the consumption?
Before I was driving, I did consume a beer at the bar. Yes.
Okay, and did the consumption of that beer impair your ability to safely operate that motor vehicle?
Yes.
Mr. Moore, you cannot answer for your client. Now, first of all, nobody's going to make me believe that the consumption of a beer impaired his ability to operate a motor vehicle. So we're going to go back. We're going to dial it back. Otherwise, I'm not going to accept this plea. And we're going to either tell the truth, the whole truth, and nothing but the truth. And if that is the truth, because it's possible that it's the truth, that he drank one beer. Okay, listen to it's possible that it's true that he drank a beer, but it's not possible that that beer impaired his ability to operate a motor vehicle. Now let's go back again. What did he have to drink before he operated the motor vehicle?
I had a beer. I was at the bar watching the game.
All right. I'm not going to accept I'm not going to accept the
ma'am.
plea.
Your Honor.
I need you to let me do my job.
Okay.
I put this in my ears, and I haven't asked anyone to repeat themselves in over 3 months. This is magic. I wish I tried this before.
I'm not going to accept the plea. I need discovery to be sent over to Mr. Moore. I need to see what his alleged blood alcohol was after he consumed a beer. And then we're going to look into it from that perspective, because I've never in the history of my life known a person to be impaired after consuming a beer. Okay?
Yeah,
okay, ma'am.
Wait.
Let me tell you this, sir. Don't keep talking to me.
Okay.
Yeah, I have that discovery, and I reviewed with them that the results were 0.166.
Well, then, if that's the case, then your client is lying on my record.
Ooh.
So let's be clear.
Okay.
If that was his blood alcohol level, then your client, under oath, I swear to tell the truth, the whole truth, and nothing but the truth, so help me God. If that is his blood alcohol level, then your client is not telling the truth on my record.
Your Honor, I'm going to say this. Okay.
I don't understand why there's conversation with me and your client while I'm trying to take a plea. That's what I don't understand. Now, the question was asked, what did he have to drink? Your client said he had one beer. So either there's something, the math isn't mathing. Something is not right. And I'm not going to just take a plea for the sake of taking a plea. Either he's guilty or he's not guilty. But if he's not guilty, then I'm not taking a plea. We're not, no.
Sure. Well, that's what I talked to you.
So do we want to go back to what did we have to drink? I mean, I don't know.
Yes. Tell me yes.
He said yes. You got to tell him what you had to drink.
Okay. I had more than one beer, Your Honor.
Ms. Ritter, you can continue.
Thank you, Judge. Mr. Hunt, and did the consumption of those alcoholic beverages impair your ability to safely operate a motor vehicle on that day?
Yes.
And Judge, for purposes of the plea, the people stipulate to the blood alcohol content of 0.16, and with that, the people are satisfied.
I'm also satisfied, Your Honor.
Let me tell you all something. If I'm not serious about anything, I'm serious about two things. One of them, they don't let me discuss in my judicial role. That's my number one thing that I care about. The thing that they tell me that I have to separate. The second thing is I take this job, this courtroom, and this process seriously. Now, what I could do is have Mr. Hunt charged with perjury, but I won't because maybe he was a little confused. But what we know is that he lied today on my record under oath. What we know is, looking at Mr. Hunt, a child could drink a beer and not have a 0.16 blood alcohol. We're not even talking about a 0.06. We're not talking about a 0.08, barely the legal limit. You sitting up here telling me it's a 1 in front of his number, and he got on my record under oath and said all I had to drink was a beer. That's insulting to the court. Your credibility is shot. And it's clear to me that at somewhere in your life, you living in a denial. You living in a denial somewhere. Now, I don't know if you drank a beer and the glass was as tall as you. But if you're going to tell me you blew up, what was the blood alcohol?
0.16.
You blew a 0.16 after you drank a beer. You shouldn't drink nothing else in your entire life, because clearly your body processes the alcohol different than everybody else's body that's alive.
These gloves can withstand 1,340-degree flames, broken glass, and razor-sharp blades because
Understood, yeah. I didn't do a good enough job prepping him.
You don't have to prep somebody to tell the truth. You don't have to prep somebody to tell the truth, the whole truth, and nothing but the truth. You don't have to prep them. You don't have to prep them. I should have been more emphatic, man. You should have, but he should not have lied. Don't come on here lying. Don't come on my court lying. Don't come on here lying. All right, court is satisfied with the factual basis as well, and I will accept a guilty plea to 1 count of operating while visibly impaired.
Thank you.
You're welcome. The court is going to set the matter for sentencing. Mr. Flanagan, November 15th. How do I look?
Just 4 matters.
Court is going to set the matter for sentencing November the 15th. Put it on my docket, Mr. Flanagan, for 9:02. Prior to the sentencing, Mr. Hunt must submit to a pre-sentence investigation and a substance abuse evaluation through the probation department. Probation is going to contact you by telephone. If they cannot reach you, they're going to leave you a message and mail you a letter directing you to contact them. You must submit to the pre-sentence investigation prior to your sentencing so that I can have a proper pre-sentence investigation on the day of your sentencing. Bond will continue with no drinking and no driving without a valid license. Anything further?
No, Your Honor.
All right, we're all set. Have a great day and stay safe.
Thank you again.
Well, Mr. Oliver, you certainly can unmute because you had to unmute in the breakout room. Someone had to unmute you. That's what's going to happen. You're not going to just randomly talk. We are literally
in court. We are in a court proceeding. My court reporter is recording. And you're not going to just literally start talking, nor are you going to get up and answer telephones while the judge is talking. I mean, I don't care who's calling inside of that room. I literally don't care. Where's Mr. Oliver? Oh, there he is. Okay. All right, I'm ready on Oliver. This is case number 086029701. The people of the state of Michigan versus Marcel Ramon Oliver. Defendant is charged with retail fraud. It's on the court's docket for a review. Who is that at the table doing? What is going on at my table? Okay, okay, blessed assurance. Okay, appearance, please. Can counsel stop doing that at the table on the screen? Can we acknowledge that we're in court? Can we do that? Okay, appearance, please.
Rakidia Hall on behalf of Marcel Oliver.
Table, can counsel move from the table? It's very distracting. It's very distracting. Can counsel move from the table? Okay, your appearance, Ms. Hall.
Rakidia Hall on behalf of Marcel Oliver. Sir, may you unmute yourself and state your full name for the record?
Unmute. Unmute, Mr. Oliver. Well, Mr. Oliver, you certainly can unmute because you had to unmute in the breakout room. Someone had to unmute you. Someone had to unmute you. Okay, so then all you had to do is tell them to unmute you, Mr. Oliver.
They're in another room. I gotta go out of here. They're in another room. Let me go.
You don't have to go out, Mr. Oliver,
You're
because clearly
Oliver.
you can tell that I can hear you because I'm talking to you.
Oh, can we hear? They're not in this room with me. They're not in this room. They're in another
Conversation. We're literally having a conversation. Mr. Oliver, please state your name.
Marcel Ramon Oliver.
Thank you so much. Today is the date. This is what I'm not going to do. I'm not going to do this.
You can't hear me. They said it's not mute. You hear me? They unmuted. Can you unmute it?
Say goodbye to your reading glasses, computer glasses, and even your sunglasses. Introducing the last pair of...
All right, let's go to another case. And then we'll come back to that one. Okay. Okay. All right.
You have to understand that Judge Bryant is a judge. And like she said, she takes her job and the legal process seriously. When you come into court and you're being disrespectful, yes, she's going to let you have it. When you go to court, you are supposed to act in a professional manner. Be respectful to everybody in the court. I don't blame her for getting mad. If I was a judge and this was happening, I'm going to go off on you.
Let's go to another case. Okay, I'm gonna bring them back out. Let's go ahead. All right. Let's go to another case. Okay, I'm gonna bring them back out. Let's go ahead and bring them back out. What I want to know is why the jail called them, because they know they heard us. Why did the jail call them? They know they heard us talking. That's why they unmuted them. Okay. Good Monday morning, Miss Hall.
Good Monday morning.
All right, let's go. Oh, okay. I know. It doesn't matter. Mr. Oliver, here's something we're gonna do. Mr. Oliver, you're not gonna just randomly talk. That's what's gonna happen. You're not gonna just randomly talk. We are literally in court. We are in a court proceeding. My court reporter is recording, And you're not going to just literally start talking, nor are you going to get up and answer telephones while the judge is talking. I mean, I don't care who's calling inside of that room. I literally don't care. They're going to not call inside the room because the person who called inside the room, they knew we were on court because that's why they unmuted you when I asked you to unmute. Like literally. So what we're going to do is make sure that we are abiding by court decorum at the jail. Now, I don't know which jail facility you're in, but I'm going to need you to abide by court decorum, and I'm going to need the people monitoring to abide by court decorum. All right. So, Ms. Hall, I think in the middle of all that, you had placed your appearance on the record. We had gotten Mr. Oliver's name, and then today is the date set for review. And hey, tell them to leave us alone, Mr. Flanagan. Just tell them that I said leave us alone. We don't need that. We don't need it. Just tell them to leave us alone for right now. Okay, today is the day set for review. Let me check my email. I did ask Mr. Flanagan to send me a copy of the Register of Action. Because this is a very old case, and Mr. Oliver is clearly in custody of the Michigan Department of Correction, and he was originally sentenced back in 2008 by my colleague whose name I cannot read. So I don't know. Oh, I guess I could go up here and see who the judge was. Nope, it doesn't tell me. So one of my colleagues sentenced him. He was supposed to do 30 days of community service. That's all he was sentenced to do. That was back in 2009. Ms. Hall, are you aware of how long he's been in custody of the Michigan Department of Corrections?
Yes, Your Honor. He was actually previously in the custody of Michigan Department of Corrections from 2009 to 2018.
And then now he's back in their custody?
Yes, he said that he's only been there for a few days. I don't know the amount of days for the current time, and he'll probably be doing at least another year.
All right, then the court is going to amend Mr. Oliver's sentence to give him, this is ridiculous.
Uh-oh.
Mr. Flanagan, you didn't tell, you didn't give him you didn't tell him, can the young lady move out of the thing? Okay, no worries, Mr. Flanagan. All right, I'm gonna amend the sentence to 30 days in the Wayne County Jail. I'll give him credit for 30 days served. We will close the case out with improvement. Bid Mr. Oliver adieu and good luck. And do you all see how we didn't need them to interrupt the proceedings to give him that remote? Do you literally see how we did not need them to interrupt the proceedings to give him that remote? I promise you, if people let Judge Bryant do her job, I promise you court will run much smoother. Ms. Hall, anything else for the record?
Nothing else for Mr. Oliver, Your Honor. Thank you.
And Mr. Oliver, you have a great day, and good luck to you. Stay safe, and this case is closed out.
It's a matter of respect. What the heck? Okay, it's just a matter of respect. When you go to court, you are supposed to show respect to the judge. These judges have a hard time doing their job. And when people are interrupting and doing stupid shit in court, it makes it harder on them. And I can see where she snapped. And I don't blame her. She's a judge, and she deserves respect. That's it. Can you imagine Bruce Manskin? Excuse me, Bruce Foreskin. Can you imagine Bruce Foreskin pulling the shit that he pulled in some of these courts? These judges would black his ass up in a heartbeat. These judges don't play. What I don't understand about this whole thing with what's going on with Jeremy is why aren't warrants being issued for contempt charges? Bruce did not show up for the hearing in front of Judge Davis. Okay, that is, or whatever judge, I think it was Judge Belitho. Okay, Bruce didn't show up. That's contempt of court. Michelle blew off her deposition. That's contempt of court. If it had been any other judge, there would have been a bench warrant issued for her. I don't understand. That's contempt of court. When you don't show up when the judge tells you to show up. That's contempt of court. If you look at Judge Middleton or Judge Simpson or any of these judges, okay, they're going to issue a bench warrant for failure to appear. I think it's the good old boy system in Florida, and this shit needs to stop. I'm serious. And the more and more I hear about this, the more and more ridiculous this is. Any good judge would have said, okay, you didn't show up for your deposition. I'm issuing a bench warrant for your failure to appear because you filed that document too late. Exactly. It's contempt. They don't do anything. Any other judge, if Michelle pulled this shit in Judge Simpson's court, or we'll say Judge Middleton, we'll say Judge Jeffrey Middleton, okay, if Lynette would have pulled that shit in his court and didn't show up, guess what? He's going to issue a bench warrant for failure to appear. Because these judges don't play. You are wasting court time and court resources. And I feel sorry for Jeremy. He's what, $430,000 into this? This whole thing is fucking ridiculous. And I'm sorry for cussing. This whole thing is ridiculous. It's like I said yesterday. If I was the judge in charge of these cases, okay, first of all, Michelle didn't show up for her deposition. So I'm going to issue a bench warrant for her arrest for failure to appear. The other cases, they want to keep dodging service. They want to keep dodging service. So I would ask Randy to write a motion and send it to me, asking me to grant a default judgment on all of them. And I would grant that default judgment. If they tried to set aside that default judgment, I would deny it. Felisa and her buddies trying to get the case dismissed. You know, Ray Bonecrusher and Felisa and all the rest of them trying to get the case dismissed. Guess what? I'm going to deny your request. The case needs to go forward. It's just a stall tactic that costs Jeremy money. And I didn't want to bring this up, but see, you listen to those. I don't listen to those idiots. I stopped listening to them. But they keep saying, "Oh, we have all this evidence and all this proof," but you never show shit on your show. You never show proof. You haven't shown proof in a year or however long this has been going on. And I'm sure that whatever evidence that Lisa and all of them are going to provide to the court is going to be hearsay evidence. It's not going to. It's going to be the same evidence that Michelle provided to Judge Thomas's. And I will say this: leave Randy alone. Okay, Mr. Shockett is doing the best job that he can do right now. And I think he's been coming back with some good ones. Randy's been writing those good motions. And that's another thing. Do you have proof that Mr. Shockett, Randy, did all the things that you accuse him of? Do you have proof of it? Because you never show proof 100% about anything that you fucking say on your channel. You're nothing but a trash channel. Okay? And that's the difference between my channel and everybody else. We provide the truth. If you want to learn about the law and law cases and how courts are supposed to work, come on here and subscribe to my channel and watch the daily dockets with the different judges. That's how you learn. That's why I'm doing this, is to teach people and to show people this is how the court works. This is how the judges make their decisions. I'm glad that I'm doing this now. I was going to quit doing it, but guess what? I changed my mind. Because you know what? People need to learn what the court is and how the court system works. Being disrespectful in Judge Bryant's courtroom is not a good thing. When you go to court, if you're on Zoom or you're in person, you dress appropriately and you act appropriately. And don't lie to the judge. Because when you lie to the judge, not only is that perjury, but it's going to be a lot worse on you. And that's a lot that I've learned through the whole month I've been doing this. I've been doing this for a full month now. And that's what I learned. And as far as BBB, maybe you need to get locked up, sir. You're in violation of an order that I issued. If I was a judge, you violated an order that I said you show up for my court at a certain date and a certain time, and you didn't show up, and you made a bunch of bullshit excuses. Then you're going to add a bunch of bullshit to that filing. You should have shut up. You should have stopped. But you didn't. So maybe Bruce needs to get locked up. Maybe that'll teach him a lesson that you don't fuck around with the courts. And no, I couldn't do this. I agree with Gail. I couldn't be a judge day after day after day after day after day. Because the jails and the prisons would be full. So I think that's it for today. I like Judge Bryant. She's no nonsense. Just like Judge Webster, she's no nonsense. Oh, I got to see BBB pull some shit in Judge Webster's court. Oh God, Judge Webster would rip his ass apart. God. In my opinion, I think the court system in Florida is a joke. And that's how I see it. That the court system in Florida is nothing but a joke. If you look at any of the cases that I brought to this channel since I started this, a lot of these judges don't play. These judges take their job seriously. These people don't seem like they're taking their job seriously enough. And I'm sorry to say that. I'm sure that the judicial system in Alabama, where I live, we have a good judicial system. These judges take their job seriously. And I think that's the problem with Florida. These people need to take their job seriously. Now, what's his name? Grob, whatever his name is. I actually am on his side. I think this judge is going to be somebody that's not going to take any of this crap. I hope and I pray that this new judge. I want to say this. I want to leave this message. I want to say this, and this message is to Michelle. Okay, you are the one that started all of this. Okay, for the reason why I don't understand why you left a nice home in Northport to stalk Jeremy to Otter Creek to try and get money, try to extort money from him. And when it backfired, that's when you started all of it. You started all of this. You think that bankruptcy is going to stop this? Bankruptcy, Chapter 7, bankruptcy doesn't stop it. It just lists the creditors. But this, Michelle, this is your fault. I don't care if John is listening or not. Okay? You need to understand this is your fault. You did this. Jeremy didn't do anything to you. And Jeremy hasn't done anything to you. You are the one that came off unhinged. And that's where I'm going to leave it. So tomorrow is Judge Stephanie Boyd's docket. I love all these judges. Fletcher is my favorite. I like Boyd. I like Middleton. I love Simpson. But that's it for today. So tomorrow is Judge Boyd. I think Saturday is Middleton. And then Sunday will be our landlord tenant. I have a doctor's appointment Monday. So I think I'm going to schedule Judge Fletcher's docket for 7 o'clock that evening. That gives me time to go to the doctor and get transportation and come home and eat something before I go live. So until then, I will see you tomorrow at 3 o'clock p.m. for Judge Boyd, Stephanie Boyd. You all have a wonderful evening. If you're not a subscriber to this channel and you like the content that's on this channel, please consider subscribing to this channel and helping this channel grow. And don't forget to hit all notifications. Notifications are working. And every time I go live, I get the notification. Excuse me. I get the notification. So that's it for today. You all have a wonderful evening. I will see you guys tomorrow. Ciao, ciao. Ta-ta. Have a wonderful evening. And I will see you again soon.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do from the highest peak, I can see it through with your care and touch. Everything's okay. Daniel, you're the one who saves the day. Daniel, you made